You can't for me. Good day, everyone, and thank you for joining today's webinar on business rescue. My name is Saman Fenyano from Corporate Education and Voluntary Compliance, and I'll be your facilitator for today's session. We will address questions related to this topic that are submitted in the comment section. For any queries not related to this matter, please send your inquiries to the email addresses listed on the CIPC website. Joining us in the studio today, we have a team led by Mr. Vuyani Ngotla, Senior Manager, Directors, Members, and Practitioners. And then Ms. Tsakani Nkuna will be doing the presentation and addressing your questions after these sessions. Please note that the current tool does not provide an attendance register. For proof of attendance register, kindly take a screenshot. We are in a process of developing a new tool that will include this functionality. Please also take a note that the recording of this webinar will remain available on both Facebook and YouTube for you to revisit at your convenience. And then I'll now hand it over to Tsakani to begin with her presentation. Thank you.
All right, thank you. Good morning once again to all our viewers and listeners, and welcome again to today's presentation. So we're from the Business Rescue Unit, and which forms part of the DMP division, which is known as the Directors, Members, and Practitioners division. In the Business Rescue Unit, we're mainly responsible for the facilitation of the accreditation of professional bodies, the licensing of business rescue practitioners, the facilitation in the administration of proceedings, appointments, terminations, substantial implementations, and also the regulations of the business rescue proceedings. We also are responsible for the recording of status reports for proceedings that have not ended within the prescribed 3 months period in terms of our legislation. And overall, we monitor the conduct of the business rescue practitioners, which refers to the regulation itself of the business rescue processes. And this is our table of contents for today. We will be discussing practitioner licensing criteria. Business rescue practitioner license reclassification is one of the main issues that we have identified to be quite an issue with regards to reclassifications and the criteria, therefore. We will be discussing status reports, the requirements that are required in the filing of status reports, the implementation rates, and the practice notes that we have actually published in the current year. So in terms of our regulations, when we are licensing practitioners, we do it in accordance with Regulation 127 of the company's regulation. And it provides 3 classifications. We have the senior practitioner classification, we have the experienced classification, and the junior practitioner classification. And what we actually get to look for, or what we require from the applicants, is actually the turnaround experience. So what we want to see is what were you actually doing in terms of the business turnaround experience when you want to be licensed as a practitioner. So we're not really interested in what the other person was doing, but what were you actually doing? What were the duties that you actually got to do? And that is what we are interested in when we are processing practitioner license applications. And this experience, which is the business turnaround experience, must be before the effective date of the Act, which is May 2011. So for any experience that an individual will have that is post May 2011, we do not take it into account, but we only take experience that is prior to the effective date of the Act. So if you have never worked before May 2011, and you have never had or any business turnaround experience before May 2011, therefore you will likely be a license as a junior practitioner, because the key thing here is that business turnaround experience before the effective date of the Act, which is May 2011. So also with regards to the classifications, you would know that with a senior practitioner, we require that you should have at least a combined experience of 10 years. With experienced practitioners, a combined period of at least 5 years of turnaround experience, and with a junior, technically less than 5 years of experience. Now, we're going to go to the reclassification of business rescue licenses. So subsequent to being licensed as a business rescue practitioner, the Commission affords practitioners an opportunity to reclassify from one license classification to another. So for example, if you were first licensed as a junior and you've accumulated some experience in business turnaround or in business rescue itself, the Commission does afford you that opportunity to reclassify from being a junior practitioner into an experienced practitioner. So you would have to request that yourself. It's not automatic that the Commission will now reclassify and say, okay, you've had this amount of years, now we're now reclassifying you. You have to request for such reclassification through the various platforms for practitioner licenses, which is through our new e-services platforms. So the Commission's determining factor for the granting of reclassification is the years of active engagement and not the factor of how many years have passed since the practitioner was licensed. As I had also emphasized in the beginning, that we look at your experience. What were you actually doing? It's not the number of years that you have had a license. You can have a license for the first 3 years and have another license, which as a junior for the second year. But if you have not accumulated any experience post your licensing, then you'll not be able to be reclassified. So the key thing here, again, I emphasize, is the experience, which is the business turnaround or business rescue experience accumulated. So the years of active engagement are taken into account when calculating the years of involvement in business rescue activities that has been accumulated. And the years of this involvement in business rescue activities are then added to the years of active business turnaround engagements that were found when the applicant was granted when seeking the classification they want to reclassify from. So I'm going to give an example again. If you are applicant A, you applied for a license, your first time application to be licensed, and you were granted 2 years, that your turnaround experience was deemed to be 2 years of turnaround experience. And you come back 4 years later, you've heard around about 5 projects, and you want to reclassify. What we will actually get to calculate or take into account is the first 2 years of experience that you were first licensed with. And secondly, we are going to take into consideration the number of years that you have accumulated in, I repeat again, the active engagement. So if you're not participating in any project, you have not had any project as a business rescue practitioner, then you won't be able to be reclassified. But if you were actually participating and had projects, that experience accumulated will be taken into account and will be added together to find the total number of years that you would have accumulated, and then you will get your reclassification as a result of those the years that you have accumulated. And then we have another type of license application, which is the renewal of your practitioner licensing. And this is an observation that has been made by the Commission, is that quite a number of practitioners are not compliant with the statutory duty of filing status reports and providing updates, therefore, till the end of the business rescue proceedings. And we have come to a decision that all license renewal applications will not be approved pending the filing of those progress reports. And the filing now means that your status report has been processed and has been approved. If it has been processed but not yet approved, maybe rejected, then we can't say that the status report has been filed. So in that regard, you will need to ensure that all your outstanding status reports are filed, which means processed and approved. And then another thing is that we have discovered is that a number of, in this filing of status report, is that a number of those applications don't contain the date or the months you are filing for, but we'll get into that into detail. And then it says the license renewals are only granted upon the satisfaction of the commission that all the requested outstanding status reports have been filed. It was also expressed on our customer note 44 of 2024 about the emphasis of practitioner license renewals due to non-compliance of status reports. And I would like to urge all practitioners out there to ensure that they comply with Section 132, subsection 3 of the Companies Act. Please ensure that you file your progress reports timelessly, on time, and ensure that you comply with these requirements that have been outlined. So with your status report, you need to ensure that you do provide an update of the proceedings. Don't just provide a status report that does not contain any update as to where the proceedings are, what you have done, and what is outstanding. So again, we emphasize that all practitioners should file their status reports, as this is a legislated obligation in terms of the Companies Act. We've spoken about status reports that it is required in terms of Section 132, subsection 3, that if a company's business rescue proceedings have not ended within the prescribed 3 months, as per the Companies Act, after the start of those proceedings, or such longer time as the court on application by the practitioner may allow, the practitioner must prepare a report on the progress of the business rescue proceedings. So what we want to see here is what has been done, what is still outstanding, how far have you come with the proceedings. We don't want to see a repetition of information from January to June and it's still the same thing. We want to see what has actually been done. And if nothing has not been done due to various factors, because the intricacies of each and every case differ from the complexity of one business rescue proceedings to another, you're allowed to outline that the proceedings are not moving due to this fact and due to this other reason. So the status report's requirement is that you must first provide a first update report, and when proceedings have not ended within 3 months after the commencement of the proceedings, the report should include the creditors' meeting that have been convened. So I'm going to stop here and try to explain something. So we have various meetings in terms of the Companies Act. When we require on the information screen, that a lot of practitioners will know that there's a question on the information screen that requires you to answer yes or no, whether the creditors' meeting has been held. So in terms of answering that question, we're referring to the Section 151 meeting, which is the meeting that will be convened to vote on the plan. But when you first provide your first update report, we want to see whether the Section 147 meeting has been held or whether the Section 151 meeting has been held and the meeting of the employees has also been held. But those crucial meetings are required to be provided in the very first update report. The outcome of the investigations of the practitioner, the date of publication of the plan, adopted actions as per the plan, and any outstanding matters at that present moment need to be outlined in the first update report. And the subsequent reports after that, practitioners are expected to provide reports on outstanding actions as per the adopted plan, the implementation of the plan, the implementation rate of the plan, which must be provided in percentages. So from the very first update report and going into the other subsequent reports, we want to see what are you actually doing. These were the approved actions of the business rescue plan. whether it's the retrenching of employees or whether it's the sale of the company's assets. That's what we want to see, and we want to see the implementation rate of the plan and the implementation itself. So you're not really required to. I know a lot of practitioners have raised concerns with regards to we can't really put a percentage into the whole proceedings. You're allowed to say, oh, well, in terms of basket one, maybe, which is the sale of the company's assets, this is how far we are. In terms of the retrenchment of the employees of the company, this is where you are. You're allowed to basket the approved actions and provide an implementation rate of each basket that you have provided. And then we go to the joint BRP's filing reports. So when an entity has 2 or more business rescue practitioners appointed, it is required that only one business rescue practitioner file the progress reports, but append all jointly appointed practitioners' signature on the progress report as well as on the form. So if you are jointly appointed on company A and you are C or D, you don't have to, both of you don't have to file the progress reports. You can choose either one of you who will file the progress report on one portal. It will migrate to the company's records. So there's no need that each and every jointly appointed practitioner actually files the progress report of that specific company. Number 2, but what is required is that all the jointly appointed practitioners need to ensure that they've signed the COR 125.1 form or the progress report. So either way, it's either you put it on the form or you put it on the progress report, but all the signatures of the jointly appointed practitioners need to be provided. In terms of the implementation rates, this is like a standard one that the Commission has provided. We've outlined that for the implementation rate, the Commission has made it easy to interrogate, makes it easy for the Commission to interrogate the status report. So this is for us to actually see whether or not there is progress, whether or not there is work that is being done. And we get to see that through the implementation rates. 1 month you're on 55, the next you're on 56. Then we get to see that there is work that is being done. And then this requirement has been set out in Practice Note 2 of 2024, and the implementation rate in percentages may be provided in the following ways: 0 to 25, which is the beginning and the initiation phase of the implementation of the plan. This is whereby most of the work has not yet been done, but you are literally in the initiation phase. You've just started out in the implementation of the plan. Second, you have 25 to 50. This is the intermediary phase of the implementation of the plan. 50 to 75%. This is the tertiary phase of the implementation of the plan. 75 to 100, the final phase of the implementation of the plan. This is where you sort of like have direction as to the completion of the business rescue plan. And then we go to the practice notes. Most of the business rescue practitioners do not follow our published practice notes, and all our practice notes are published on our website. So if you do want to view any published practice notes, you have to navigate to our website. Please familiarize yourself with the practice note to guide you in all of the involvements within the business rescue unit, and also with any developments that are currently taking place or any decisions that the Commission has taken, that such are communicated through our practice notes. So again, please regularly navigate into our website to find such updates. Practice Note 2 of 2024 provides for status report requirements. I've already outlined issues pertaining to the first update, what is required in the first update. Number 2, required in reference to the subsequent reports that are required, the implementation of the business rescue plan. We go to Practice Note 63 of 2024, which deals with the automation of filing of status reports, substantial implementation and terminations. This was when we had moved from now manual processing now to our new e-services portal, and where everything is done online on our new e-services portal. Notice 62 of 2024, which refers to the academic requirements for business rescue practitioner licensing. We have observed that quite a number of times we receive applications from from applicants who want to be licensed as business rescue practitioners who do not satisfy the requirements in terms of the NQF levels that are required to be licensed as a business rescue practitioner. We have Customer Notice 44 of 2024, dealing with the rejection of BRP license renewal applications pending the filing of status reports. This basically deals, as discussed before, deals with the non-compliance of practitioners with the filing of status reports. And again, we do urge practitioners to comply with Section 133 of subsection 2 of the Companies Act. And the last one, which is Practice Note 2 of 2025, which was also emphasizing on the need to comply with the filing of the progress report. So all of those practice notes can actually be found on our website. You can actually navigate there and get to read them as they provide more details. And we have reached the end of our presentation. Thank you.
Thank you very much, Tsakani. We'll now begin with questions and answers session. I just want to find out from my colleagues if there are any questions on the chat box, but I don't see anything. Lerato?
No, unfortunately, there are no questions, Simon.
Okay. Thank you very much. And then that brings us to the end of today's webinar. And then we hope you found the session valuable and that it will be useful for you going forward. Thank you for joining us and have a great day. Bye-bye.